One of the most common questions I get from family and professional fiduciaries with a property to sell is, how do real estate commissions work? And I read something recently about real estate commissions changing, but I didn't understand it. Can you explain those changes? These are great questions. Struggling to understand how real estate commissions work is completely normal. In the US, most people never sell a home in their lifetimes, and if they do, it's once or twice at best. In this video, I'll explain exactly how real estate commissions work, why they're helpful for fiduciaries selling probate and trust real property, and what's changed in real estate commissions recently. Also, at the end, we'll go through why these changes are good news for fiduciaries. If we haven't met, hi, I'm Andrew Vries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions, and with this channel, I'm here to help you avoid costly mistakes. If this information is relevant to you, please consider subscribing below. So let's dive into real estate commissions. How real estate commissions work. One of the most common questions I get on a regular basis is how real estate commissions work. I like to break it down into two parts: seller agent commission and buyer's agent commission. There is generally a commission paid to the agent that represents you as a seller in a sale. That is commonly called a seller's agent. This is the fee that a seller will pay to a listing agent to represent them in the real estate sale. The services they provide for that fee can include the following and often much more: helping you prepare the property for maximum resale, which can include clean out, cleanup, painting, flooring, gardening, and more. Helping you price the property correctly for the market. Making sure you correctly disclose information about your property to prospective buyers. Marketing the property extensively to prospective buyers and their agents. Procuring offers on the property, vetting the quality of those offers, and helping you negotiate the best offer into contract. And managing the process during the escrow to ensure that your sale closes on time and for the best value. There is also often a commission or fee paid to the agent that represents the buyers in a sale. I like to look at this buyer's agent fee, which is often paid by the seller, as one of the biggest marketing tools a seller can use, because it taps into a network of 5,500 realtors around the Bay Area with buyers that a seller can tap into to get their home sold quickly and efficiently and for a great price. A buyer's agent will help develop a plan for finding the right property for their buyers, providing in-depth market knowledge. They'll identify the right properties and schedule showings. They'll help write and negotiate offers. They'll help review disclosures with buyers and conduct inspections on the buyer's behalf. They'll work with lenders to ensure the buyers get their loan and that the sale closes smoothly. And ultimately, they'll be working to protect the buyer's interests while ensuring that the buyers know where the seller's responsibility ends and theirs begins within a purchase. That said, for many decades, typically the seller has been responsible for paying the commissions for both the listing agent, representing the seller, and the buyer's agent, representing the buyer. Until recently, that is. So what's happened recently? In 2019, sellers in Missouri sued the National Association of REALTORS, commonly known as NAR, and various real estate brokerages, alleging that NAR colluded to inflate real estate commissions for sellers by asking sellers to pay both sides of the listing commission and listing those commissions to the buyer's brokerages, which are typically around 2.5 to 3% of the sales price on their locally affiliated multiple listing services, known as MLSs. A jury in Missouri in 2024 found in favor of the seller plaintiffs, and this led to a wave of copycat seller lawsuits across the United States. Instead of appealing the verdict, NAR and several brokerages reached a tentative settlement in the Missouri case and the class in the copycat lawsuits across the country. So what was settled and what will this possibly mean going forward? NAR and brokerages agreed to pay damages to the class of plaintiff sellers to settle the lawsuit without acknowledging any wrongdoing. This was done to avoid the expense of appeals and possible future litigation. As part of the proposed settlement, NAR also agreed to no longer post commissions offered by brokerages representing sellers to buyer brokerages on NAR-affiliated multiple listing services. Sellers and their brokers brokers can still offer a commission or a fee to the buyer's broker to market their property and attract showings. It will now just need to be done off the multiple listing service. In addition, all brokerages representing buyers will be required to enter into a buyer-broker agreement with their buyer before going to work for that buyer. This buyer-broker agreement, which was already in use by many, will spell out the duties of the buyer's agent to the buyer and list the ways that that buyer's broker can get compensated for their work on the purchase. These forms of compensation can still be an offer of commission or another fee coming from the seller's broker, or the buyer can pay the commission, a flat fee, or an hourly rate to the buyer's agent. As one can likely imagine, most buyers in the Bay Area, who are often stretching to put together a down payment to purchase a home, will likely not have the additional funds on hand to compensate their agent directly. And lenders have yet to allow a buyer-broker fee to be folded into loans. Despite the media coverage, what the settlement does not or likely will not do for sellers. The settlement does not affect offers of compensation to a listing agent for all of the work they do on behalf of the sellers to get the property sold for top dollar. It does not prohibit brokerages representing sellers to make an offer of compensation in the form of a commission or other fee to buyer's agents as a marketing incentive to get them to show and sell a property. They just need to make those offers off the local MLS services. These offers of compensation to a buyer's broker are still one of the most effective methods for harnessing the power of thousands of real estate agents in the Bay Area working with buyers to attract strong interest, showings, and offers in real property sales. One of the things we believe this settlement will not do is it will likely not protect buyers, as it could affect the level or quality of representation that these buyers received for what is likely one of the largest financial transactions in their life. It will likely also not protect sellers, as there could be a creep towards dual agency, where an unrepresented buyer is duly represented by the seller's agent as well, which can be construed as a conflict of interest in fiduciary real estate. This has been the case in commercial real estate sales for years, where many of the sales have been off MLS and that there is a propensity for dual agency. Note that as we represent family and professional fiduciaries only, we never represent buyers on the properties we are selling for our clients, as that would be a conflict of interest which could cause problems later should a family member or their attorney or the court question the fiduciary's actions later. These settlement actions will likely also not protect sellers, because one of the top causes of lawsuits in real estate transaction is when a seller sells a home to an unrepresented buyer or a poorly represented buyer who is not provided effective buyer-broker representation during the sale. They may not have understood the purchase contract. They may not have understood the investigation process. They may not have understood the contingency and disclosure process, and later have buyer's remorse after the purchase and then file a lawsuit. This settlement action will likely also not make home prices go down significantly, if at all, because the real estate market in the Bay Area and much of the country is influenced to a far greater degree by limited housing supply and strong buyer demand, as well as lending interest rate fluctuations, than by relatively small fees that seller brokers offer to buyer's agents to show and sell their properties. So why is this settlement actually good for fiduciaries? The new ways of negotiating buyer's agent compensation is bringing more transparency and general education in the community about how real estate commissions or fees in purchases and sales work. This will be beneficial for communicating with heirs, beneficiaries, conservatees, family members, and other parties with an interest in the sales. The new rules will force buyer brokers to better articulate the value they bring in a real estate transaction and further highlight and educate the public on the dangers of having a seller's broker represent both sides of a transaction. The new rules could also allow for further negotiation of buyer's agent fees with listing brokers and buyers directly, which could facilitate greater transparency and perhaps lower buyer agent fees to some extent. The new rules should also help create a further record of what a fiduciary did to negotiate all fees in a real property sale, including buyer-broker compensation. This record is of utmost importance should the fiduciary be questioned later. Now that you've got a better handle on how real estate commissions work and what has changed recently, you might be wondering how probate and trust sales differ from standard real estate sales. In this video right here, I will walk you through how probate and trust sales come with unique legal requirements, court oversight, and additional complexities that most agents just don't have experience with and that can cost you as the fiduciary a lot of time and money. So watch that video and I'll see you over there.